Okay, I think we've got everybody so far. All right, good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Understanding Child Custody Issues. My name is Nia Murray. I am Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Mr. Rashad Cave. Also, on behalf of our presenting partner with the Houston Bar Association is our presenter today, Ms. Deborah Patterson with Harris County Domestic Relations Office. But included in the partnership is also Lone Star Legal Aid, Houston Volunteer Lawyers, the Earl Carl Institute, Harris County Appraisal District, and Harris County Tax Assessor Collector's Office. And together we make up A Month of Service. And basically what A Month of Service is a collaboration of these 8 different organizations that come together on a monthly basis to offer a variety of workshops relative to community empowerment, asset building, asset protection, and maintaining of generational wealth. We started doing these workshops out in the community where we would go to a different neighborhood and offer these workshops in person on a monthly basis. But now, due to COVID, we've had to adjust and adapt and go virtual, which has allowed us to actually expand and reach an even larger audience and create an even larger impact by reaching so many different people and providing information and resources to the communities that we all serve. So we're here today to provide some information for you that's been very critical over the past couple of years, especially due to COVID. Understanding child custody and what's involved in it and what your options are is something that a lot of folks have had questions about and need continuing information and resources and updates on. So we're here to provide you with that information for today. So later on in the presentation, we will be answering questions that anyone may have. We're encouraging our participants to feel free to type your questions into the chat, and we will address them at the end of the session, or you can wait until the end and unmute yourself and ask your questions directly of Ms. Patterson, whatever it is that you have. However, we want you to keep in mind that the information that we do present here today is for educational purposes only. It is not legal advice. However, we do encourage you to reach out to the Domestic Relations Office or to our legal service partners for more detailed or more one-on-one assistance or for any civil legal services that you may need. In addition to that, this session is being recorded as well as being broadcast live on our social media platform at Amos Houston TX. So we ask that you try to keep your questions to be as general as you possibly can so that your personal detail information is not getting out there for everybody to have access to. So we want to protect your privacy as much as we possibly can. So just ask you to keep your questions to be general and just to keep that in mind. So also the information that it is presented here today, it is not just relative to the city of Houston or for Harris County. Information that Ms. Patterson will be presenting is relative to Texas laws. So regardless of where you are, if you are in somewhere in Harris County, Fort Bend, Brazos, Corpus, wherever you're watching from, then know that this information is relative to you as well. So with that being said, I'd like to have our partner to go ahead and introduce themselves, and we'll get right on into our presentation. So Rashad.
Yes. Again, thank you all for joining. We really appreciate it. On behalf of the city, we want to thank Ms. Patterson for coming and actually participating in this course as well. A lot of times we understand on the city side that that there's a lot of concerns, a lot of issues that we have in the city of Houston, even though we have some issues that we're taking care of and that we're doing pretty good. So on behalf of the Department of Neighborhoods, one of the reasons why we truly engage in courses and or informational things such as the Month of Service is truly to make sure that we can continue to try to add value to Houstonians. Don't be weary, even though right now I'm sure you all probably, especially the 2 people that we have online, probably are assuming that this is just a very low turnout, but it actually isn't. We don't only record it, but it's also streaming live, as Nia just mentioned, to you all, which means that normally by the time it is shared, by the time it's communicated, it's roughly over anywhere between 250 to 300 people that will have looked at this, reviewed this, or understood this, or if your question is general, make sure that you also know that there's other people that are might be listening to you or might be asking or thinking of something. So don't be afraid to mention, ask your questions, and be to the presentation that we have here today. The Month of Service is a great program. Feel free to tap in to the NRCDC website to also to look at the calendar
We're kind of losing you,
for all
Rashad.
the other events and scheduled. Okay, okay. That in conclusion, I'll hand it to Ms. Patterson. I don't know what part y'all didn't hear or not.
It was
so.
it was a little choppy, but we got the gist of it, I think. So thank you. Ms. Patterson, would you like to go ahead and present
Sure.
and introduce
Sure.
yourself?
My name is Deborah Patterson. I am the Director of Family Court Services as part of the Domestic Relations Office. Prior to coming on here a little over a year ago as the director here, I was an associate judge in the 257th District Court here in Harris County, and I served for 13 years. Before that, I had my own practice. I didn't go to law school until I was 44 and decided this would sort of be a second career. I enjoy being on the bench. I figured last night I've probably done about 25,000 divorces. So and modifications and agreements of people. So I have a lot of experience in terms of dealing with some of these issues, and I welcome your questions. I can't give you legal advice clearly, but there's a lot of generalized questions that people often have with regard to custody, and hopefully we can get to some of those. I want to give you a little bit of background of what the Domestic Relations Office is. It is a department that's created by the county commissioners of Harris County. And originally we started in 1977, and we did enforcement kinds of things where we enforced child support, we established paternity. We did a few of those issues. The agency has grown dramatically over the years. We finally added possession and access enforcements. So if you were not having either getting your child support or you were not being allowed to see your children based on a court order, we could get involved and help you do that. In 1994, we started doing child custody evaluations and adoption evaluations. According to the Texas Family Code, the law that we all go by when we're doing family law as attorneys, those kind of evaluations are required if parents or the judge requests it and an order is given to us. We spend many months going out doing a very detailed evaluation, and we'll talk about that in a minute, on custody. And also if you choose to adopt, whether you're adopting a relative or a stepchild or a child that you don't know, if an adoption happens in one of these counties, we will do the adoption assessment here in Harris County for the people who are the kids who are living here, and make a recommendation to the court about whether or not the adoption should happen. We then, after we started doing the child custody evaluations, that came over from juvenile. So what gradually we've done is we've taken some of these services from other agencies and sort of joined them into the DRO. In 1996, we started doing mediation. Originally, mediation was just for civil cases, that you and your neighbor were arguing about a fence, and people would go to mediation, have a mediator sit and try and negotiate a deal. In the 90s, people started talking about having family mediations. A lot of people said, oh, that will never work. It's too emotional. People are too upset. It's too complicated. But we found over the years, and we here at the DRO have some real experienced mediators, that most people prefer to reach their own agreements. They would rather reach agreements with regard to their children than have a judge, a stranger, make those determinations. Because when you go to court, the judge doesn't get to hear all of the nuances of your family. They get to hear little bits and pieces of what your situation is, and they have to make a decision. So they found that mediation gave you the opportunity to really talk about what your concerns are. Quite often people were arguing way up here about an issue when really down here was the real issue. And if the mediators could get to those issues, they were able then quite often to settle. So our mediation program began to grow and grow. And now we have at least 5 mediations or 6 mediations happening every day, and sometimes more. We have the professional mediators and we have our evaluators doing mediations too. So that's one of the big things that we do as well. We also in 2003 started community supervision, which was a service to people who were placed on probation by the courts, either for child support, not paying their child support on time or at all, or not allowing visitation per the court order. So instead of looking at jail time, sometimes the judges placed them on community supervision, where they would come over to our office. They would meet with the community service officer on a regular basis and sort of encourage people to follow the court order and continue to follow the court order. We started our supervised visitation program in 2019, and we have 7 different sites all over the county. And those are supervised visitation centers. Quite often they're at churches, and we staff them. We do it every, first, third, and fifth Saturdays. Well, actually the Saturdays after the first, third, and fifth Fridays, so people don't get confused, for several hours. They have a police officer, they have staff, and those are people who want to continue to maintain access and contact with their children, but the court has determined that they needed to be supervised. So we have quite an extensive supervised visitation program that occurs all through the year, and that has been quite successful. We now are assisting with modification, changing the underlying orders for people working with people to change their possession and access. Sometimes your orders with regard to possession and access aren't really clear, and people start getting into fights, not physical, but arguments about what does that really mean? Am I supposed to have the kids this week? Are you supposed to have the kids this week? And so it's a way sometimes to help clarify those orders. So a lot of the arguments and consternation kind of dissipates. And now we've just started this year, we're trying to work with self-represented clients. So those are called pro se clients who don't have attorneys for one reason or another. And we're trying to work with them. We don't give legal advice, but we can look at the court order. We can tell you if the judge is going to approve it or not, because that's always a frustrating issue for people who are trying to work the legal system by themselves. They find it difficult to go in and deal with the court staff. And I totally understand, because if you don't know what you're doing, it's very frustrating and very hard to get some of these things through the system. And so that's another service that we're offering. And so our DRO that has the legal department to help with some of these things, and then the family services, which I'm the director of, we help essentially the courts in sort of dealing with these custody issues and matters that they're constantly dealing with. I'm just wondering if there's a question, but okay. I just want to talk a little bit about what we do here. I think I've already mentioned it. We do the custody evaluations. What happens is if there's a court order, it comes over to us. It's ordered by the judge. Sometimes the parties can request it. Sometimes the judge decides to request it. It can be in the middle of a divorce. It can be in the middle of what's called a modification, where you're trying to change the previous order and fix things, or change custody, or change visitation or rights and duties. So that comes over to us. It's assigned to an evaluator, and they have 90 days to complete it. Now, our evaluators, most of them are licensed, either social workers, PhDs. They're qualified people to do these evaluations. They take extensive training not only prior to coming here with their license and while they're here. We do have a couple people who've worked here for over 20 years who are not licensed, but because they've worked for the DRO and taken so much training over these 20 years, they're also qualified to do it. The reports usually end up to be about 25, 30 pages. They're very detailed. We talk to everyone. We make home visits. We go into the home and see the children with mom. We go into the home and see the children with dad. We talk to collateral contacts. We get CPS reports. We get criminal histories. We talk to any therapists that the parents or the children have talked to, look at any medical records. And then we write up a very detailed evaluation that is reviewed by, one person writes it, but then we have other people peer review that look at it to make sure it's clear and concise. And then we give a recommendation at the end if we can. There are certain requirements in the family code that we have to do, certain things we have to look at in order to make the recommendation. So sometimes we do the whole thing, but because we haven't been able to see mother with the children for some reason, we can't make a recommendation then, but we can still give all the background information to the court that we've gotten over those 3 months. The courts find it very helpful. Judges cannot go out to the houses. They can't really talk to the kids. They can't talk to the parents the way they would want to. And as I said, they just get little bits and pieces in a hearing. No matter how good your attorney is, no matter how hard they try, they're given a finite period of time generally to present your case, and you can't get everything in. With an evaluator, you can. And so we do not do psychometric testing, which some of the other evaluators do, private evaluators, where they give testing and they make predictions or recommendations based on that testing, as well as other things that they observe. So that's one thing we don't do, but I think they've found that our evaluations are complete and extremely helpful. That's the custody evaluations. We also do the adoption evaluations. And in the family code, it also says if you're going to do an adoption, you have to have an evaluation. Now, those only take 2 months. They give them an extra month for the custody, because generally those evaluations are a little easier. We still get criminal histories. We still look for CPS records and all the other records we might get. But we do those with a family who's sort of ready to move ahead. They want to get it done. They provide the records for us. If the parent of the children is contesting that adoption, meaning if their rights have not been terminated to make the child free for adoption, if the parent is fighting that, then we do talk to the parent and find out what their position is. If we satisfy all the requirements in the family code, we can make a recommendation. If we don't, sometimes we just say the home is capable, their parent is capable and suitable, but we can't make a recommendation. The courts they do find that helpful, and they use us a lot with regard to all the adoptions that go on here. So that is a necessary part of what we do. The other thing we do is the issue-based investigations. Sometimes the court will be in the middle of a hearing and they will say, I want to really know if this person's house is really almost like a hoarder's house. I want somebody to go out to the house. And so they ask us in a very short order, and they check a couple boxes saying, we want you, one of your evaluators, to go out to the house and look at this and this and this, and we'd like you to do that within a week or so. If they want CPS records, clearly it takes a little bit longer, but because we're at the mercy of CPS to give us the records when they can. But it's a service offered to the judges to help them make decisions when there's certain things that they just don't know unless they have eyes on the child, eyes on the house, look at certain records. And so they ask us to do that. And so we get a certain amount of those, and those are called issue-based investigations. So we have a whole staff of our evaluators who are just constantly doing all these evaluations, getting records, writing them up, presenting them to the court. Occasionally, the evaluators have to go in and testify at court. Not always, and probably most of the cases settle without that having to happen, because once our evaluation comes through on anything, most of the attorneys or a lot of the attorneys advise their client, look, this is what the evaluator suggested. Chances are this is what the judge is going to do. Let's take this to a mediation and see if we can't fashion an agreement you both can live with. Sometimes we do have to go testify, more in the custody battles than in the adoption ones. I mentioned mediation. So a lot of times after evaluation is done, or even before it's done, parties come to us for mediation. And some of you might have been through mediation. Basically, one side sits in one room, the other side sits in another room, and the mediator goes back and forth to see if they can broker a deal. Usually that takes several hours at least. It's a tedious program, but we have about an 81% settlement rate. So usually it ends in an agreement. When there's an agreement, the mediator writes it up and is very detailed about it with the help of the attorneys. And sometimes we don't have attorneys. Sometimes we just have two parents that have been ordered to mediation. But once the mediation is written up and signed, it becomes like an order of the court. It's enforceable in terms of the judge will sign a final order based on that mediated settlement. So it's important that when people do a mediation, they sign it, they understand they've agreed to this, and this is going to become their final order. This is going to become the order from the court. The code, the family code that I spoke about, speaks a lot to that. The fact that these mediations have been given, or these MSAs, these mediation agreement, have been given a lot of authority to memorialize what these people's wishes are and what their agreement is. So you can't sign the agreement and then go into court 3 weeks later and say, I've changed my mind. You can't do that. On down the road, you could file something and start a whole new case, but with the mediated settlement that you did, it is what the agreement is going to be. So we do those. We have 6 mediators. They're working every day. Used to be they all came into the office, which a lot of people liked, because I think maybe there's a discussion about if coming into the office is better and results in more agreements. And there's also a side that wants it to remain on Zoom. A lot of people like the Zooms. It's easier to get to. It's easier to, you don't have to come down to the office. I was saying that when I was a judge and we did CPS, we did them on Zoom, and we had a lot more parent participation, because it's very hard sometimes for people to get transportation down to our offices and stuff. And so people on Zoom, we have a high participation rate. The only problem with people coming on Zoom is sometimes they don't think of it as a serious matter. So we are requesting that people either participate in their attorney's office with their attorney next to them, or if they're pro se, that they have nobody else in the room with them, because it's as if you were sitting in somebody's office. So we do have a lot of people who agree at the mediation. We do have, all mediations don't come to an end and end the case. Sometimes they give you a temporary order, which means that if parents are fighting and arguing and they can't finalize, there's no trial set, sometimes there'll be a temporary order agreed to, or you can go to court and get a judge to say a temporary order that says basically, right now, this is how it's going to be. Might not be that way when this is all finalized, but right now, this is where the kids are going to live. This is who's going to do what. This is who's going to pay, if anybody's going to pay. And that becomes a temporary order. So sometimes our mediations are temporary. Sometimes we do partial mediations that we agree on 10 issues and we leave one for the judge to decide. So there's a whole gamut of how you can do a mediation. But our goal is to help people settle their differences, be comfortable with them, feel like they participated, because once it's over, it's ultimately better for the kids. And so that's what happens with the mediations. And they all have to, for us to do a mediation here, they have to include the children. We will do divorces where we will help you divide up the property, but there has to be child issues as well. So if it's just a couple with no children, they don't come to the DRO. They go to private mediators, and many people go to private mediators. There's a lot out there, but we don't. They prefer, a lot of people prefer to come here, and we are constantly moving people through having mediations. We try and get them in as quick as possible. So that's where we are with regard to mediation and the services we do. Now, talking about custody, a lot of people say, I guess you have to think about what is custody, because a lot of people would say to me, well, I want custody. And there is no such thing as having custody exactly in the family code. They talk about rights and duties and who gets to decide certain things for the children. And this is in divorce. As I say, modifying the divorce. Sometimes there's just lawsuits about the children called suit affecting parent-child relationship. Those are usually included with the paternity action. So there's not always just divorce that we're talking about. Right now, about half the babies that are born in Harris County are born to people who are not married. So, and sometimes they've lived together a very long time, but they haven't gotten married. So there's other things that have to be considered. We have to determine who the legal father is. Just being on a birth certificate doesn't make you a legal father of a child. You can sign certain documents called acknowledgements of paternity. If the dad signs and the mom signs and mom's not married to somebody else and it's properly filed, then that can make the father who's not married to the mother a legal father. He can have been married to the mother when she had the baby. He's the legal father. But a lot of times people don't understand that there's something else that has to happen before people are named the legal father. Having DNA doesn't automate it, even if it shows that these men are the dads, that doesn't automatically make you the dad. There's certain things that have to do. So sometimes in mediation, or sometimes when we're dealing with custody or there's hearings, if mom and dad both swear that he's the dad, then you can agree that he will be the dad, and the court will issue an order saying paternity has been established. So that's a lot of times in the suit affecting parent-child relationship, not a divorce, but just a lawsuit talking about the kids and how you're going to relate to one another. That's part of what happens is the paternity action. In the divorce and the modification and the suit affecting parent-child relationship, parents come to court and they are stuck sometimes in terms of what to do with the kids. Sometimes people have children and have not really had much of a relationship with each other. They've dated each other for a very short period of time. They have a baby, and then they're expected to parent these kids for the next 18 years when they barely know each other. So there are things that we try and do in terms of recommendations and stuff to put them on the path where they can become more knowledgeable. They can learn to co-parent, because the ultimate goal when people separate and are not both living with the children is to be able to co-parent these kids. And there's a lot of different ways you can do it. If parents have been married or had long relationships, sometimes there's been problems and trust issues and hurt. And those are issues that have to be sort of dealt with and hopefully put on the back burner, because the children's best interest is what the courts and our agency are most interested in all the time. And so that's what we're hoping for, that we can turn these parents around to look at what's in the best interest of these kids. It's not always easy. Sometimes there's been domestic violence in the case. And then we have to determine what's happened, both the courts and the evaluators, when they do a custody evaluation, they have to determine what's happened, if the children are safe, if the parents are safe. That's sometimes where visitation, supervised visitation comes into play. There's other things that we can do in orders or suggestions that allow the parents not to be in the same vicinity as the other parent. Quite often the domestic violence has to do with the other parent and not the children. We look at whether or not the kids have been privy to that domestic violence. It's a very serious matter. We take it seriously, and we try and get all the information we can, and then we try and fashion recommendations that will keep everybody safe and put everybody in the best light and allow the parents to still have relationships with their kids, because kids need both parents. As we do the modifications and the paternity action, we're looking at when we do the evaluations, we go in and we talk to the parents jointly. We talk because we want to see how the parents get along. They come into the office usually for a joint meeting. Sometimes they don't like it because they're very mad at each other. And we try and gauge where they are with that. Then we make home visits where we see each parent with the children, and we see how they relate. We see what the house looks like. We see the environment. We talk to each parent about their concerns and their issues. And we've learned as the evaluators to kind of read between the lines in terms of what's really going on with these parents and these kids. Most kids, and even if they're little 4-year-olds, they want the arguing to stop. They want the stress to stop. There's one little thing on Facebook with this little tiny girl talking to her mother, asking if she and her dad can't please get along and be happy and smile at each other, and can't they just ratchet it down a little bit? And her mother's listening and she's saying, can't you just get along? And she's 4. And that is a common thing. I remember before I was a judge, I was an attorney for the children and going to visit a child. And the 7-year-old looked at me and he said, you know, we're in a war. And I said, what do you mean? He said, well, my mom and dad, this is a war. And it was a war. And the casualties of that war are the kids. And those of us who work trying to help these families get to a better place are well aware of that. And we try and keep that in our mind at all times. There is, let's see what I was going to talk about. Oh, I know. I'm going to go back to the whole custody issue. What is custody? Nobody has custody. Somebody will be appointed as the managing conservator of the children, meaning it's like a statement of custody, but in Texas law, you're called a managing conservator. Parents can be joint managing conservators, where you're both managing conservators, or one person can be the sole managing conservator, and the other parent is the possessory conservator. In the code, there's lists of rights and duties about what you can do depending on what title you've been given, either by agreement or by the courts. But that doesn't even really get you there. What gets you there in terms of who is making the decisions for the kids, the rights and duties? So basically, there's some very specific rights and duties. There's about 10 of them, but there's about 4 that are really important. One is who's going to determine the primary residence of the child. That usually becomes the corner pin in terms of who has what everybody calls custody. If you're awarded the right to determine the child's primary custody, then you have the right to decide essentially where that child lives. And the other parent usually has possession and access of that child. Now, some of the orders can be a little more convoluted, and some parents have tried to go for more of a split of week on, week off. Dad gets 1 week, mom gets 1 week. Dad gets 1 week, mom gets 1 week. The courts have been hesitant to do that, and the evaluators have been hesitant to recommend that generally, because that's very tough on kids. It might work for the parents and they like it. And because they get to see their kid wake up and take them to school and do all that kind of stuff. But switching your residence every 7 days is difficult for children, especially smaller ones. 17-year-olds, quite often they do what they want. They have their car, they go and sleep and stay with whatever parent they want. But we're talking about littler kids. And so the right to decide the primary residence is a big right. Then there's also the right to determine education decisions. Well, if both parents have that ability, you're just setting them up to have big arguments, to decide, well, I want him to go to my school, it's zoned to my house. Well, I want him to go to my school, zoned to my house. So generally, that's a right that is assigned to one parent. And usually it's the parent who determines the primary residence. Now, does that give that person custody? I suppose you could say that, but that's not really used to define which parent is what. Then there's also psychological and psychiatric decisions. Who makes those decisions? Now, quite often, those can be joint decisions where both parents weigh in, and you can try and get a tiebreaker of maybe the child's pediatrician to decide if this child needs to see a psychologist or a psychiatrist or something like that. Invasive medical is another important right. And that is a right that talks about if a child has to have surgery, who makes that decision? Now, if you're a sole managing conservator, basically you get all the rights by yourself. The possessor is a conservator, just gets to sort of visit. But when you're joint managing conservators, and most people are appointed joint managing conservators or their children, you have to decide what to do with that right. And a lot of times that becomes a joint right. That is, you also use the child's pediatrician to decide that if you can't decide. Most parents can decide that. That's a pretty serious thing, unless they're fighting a fight that has very little to do with the children and more to do with the parents' angst and anger between each other. Most parents are able to get together and do that. A lot of times when they're fighting and in the midst of this procedure, whether it's a divorce or a modification, tempers run high, feelings run high, and we found that after things are settled, quite often people are able to get into a better place for the benefit of the kids. So those are the rights and duties that we talk about quite often when we talk about custody. And so the parents who've been through it, who've learned, and that is the same whether it's a modification of a previous order, which would either be a divorce or a suit affecting parent-child relation, you can modify those. And there's criteria for when you can modify them and why you can modify them, but you can change them. And so that you can change the rights and duties. You can change who has primary decision-making power with regard to the residence and education. And that's how we sort of decide who's going to be in charge of the kids, who's going to take care of the kids. And it's all governed by the Texas Family Code. Now, as creative as the parents can be, and the mediator can be, and the judge can be, sometimes you can fashion detailed agreements or orders that are different. Some parents like a 2-2-3 schedule. Somebody gets Monday and Tuesday, somebody gets Wednesday and Thursday, and then every other weekend to the one parent, And so, but then again, that's changing residence even more. Some kids can deal with that and like it. But quite often, it's usually one parent decides the residence, the other parent gets first, third, and fifth weekend from Friday to Sunday. Now, the parent who has possession or gets possession and access of his kids can ask for expanded visitation, which means not only do you get those weekends, but you can start your weekend from school on Friday to return to school on Monday. And instead of getting 2 hours on Thursday evening for dinner, you can have overnights with the child. So essentially you could have for first, third, and fifth weekends, you could have from Thursday to Monday. And then on the off weekends, you would just get Thursday overnights. And what that does when you look at, and then there's extra time in the summer, spring breaks, things like that, Christmas, holidays that are usually switched. But what that does is it gives the parents almost a 50-50 split. It's about a 47-53 split if someone asks for an expanded order, expanded visitation schedule. But then what happens is then people start saying, well, if I'm almost getting my child 50% of the time, I'm getting my child 47% of the time, why should I have to pay child support? Well, the reality is right now, that's what the code says. The person who has possession access due to a standard possession order or an expanded generally pays child support. Used to be that the courts would not sign an order or agree to an order unless it had child support. And the courts had the ability to do that. They could say, yeah, you have an agreement, but I'm not going to sign this unless you have child support. Now, if it was a mediated settlement agreement, they didn't have that option, but that's just a recent thing that made the agreement so binding. But as people have changed and the courts have changed, they've become a little more lenient and a little maybe more realistic, and allow the parents to work out some child support sort of creative solutions. Maybe somebody pays for daycare, maybe somebody pays for camps. A lot of times it depends on the income of each parent, but there are caps on how much parents are ordered to pay from the courts. And so in these orders that these courts give down and sign, they're very detailed orders. They try and think of everything, because attorneys and judges are paid to think of all the things that could go wrong. And they're charged with trying to put into the order enough information so everybody knows where they are, what their responsibilities are, when they're supposed to do things, no matter what. You can't always do that. So there are issues about certain things. If you pick up from school, for instance, a parent is ordered to surrender the child at school to the other parent. Well, that's hard to enforce because the parent's not there when the other parent picks the child up from school. So there's some things that attorneys are constantly working on, trying to make better, trying to figure out how to make these orders enforceable enough that these people don't have to continue to fight. And so that's basically where they are with regard to possession and access of these kids. There are also other rights and duties, passport language that is quite often put in a custody evaluation. They can determine who's going to apply for the passport. They can determine who's going to hold the passport. They can make a statement about if somebody requests the passport from the other parent, then what the parent requesting the passport has to do in terms of the itinerary, so parents know where their kids are. Now, if there have been issues, if there have been threats that people are going to run with the kids, then sometimes there's restrictions put on that passport. And so it's absolutely on a case-by-case basis. And that's what people try and present either in mediation or to the judge to allow those other things to be considered when reaching agreement or writing an order. As evaluators, we do talk to the children. Sometimes the courts have appointed attorneys to represent these kids, and those are called, in CPS, they're called ad litems. And those are attorneys who are supposed to do what the child wants, or at least advocate for what the child wants. Now, clearly, that puts some of those attorneys in a tough spot, because if you have a 12-year-old who sincerely wants to go home to a parent that's not very good for them, that attorney makes it clear that that's what the child's wishes are. In private cases that are not state cases like CPS, an amicus is appointed. And those are attorneys who are there to investigate, like an evaluator would, and to give recommendations to the court about what should happen to those kids. They talk to the kids, they talk to the parents. When we're doing an evaluation, quite often they talk to us. So there's a lot of people involved in trying to make a decision with regard to what should happen with these kids. They are extremely helpful, but they can be very expensive for the parents. If parents don't have a lot of money quite often, or are really working hard and things are tight, quite often the court will ask for an evaluation through the domestic relations office before they appoint an amicus. Because with appointing an amicus usually comes a court order that says, each of you pay this amicus $2,000 by next week. And they run their fees just like an attorney does, even though they might run it and reduce their fees. It's still an ongoing process that they are charging the parents for the services they do. They get very involved in the case. A lot of it depends on if this is a case that is just a bench trial, meaning just to the judge, or if it becomes a jury trial. Because there are certain things in Texas, in family law, that you can take to a jury. So sometimes people would like to take their cases to a jury trial. As a judge, I never thought that was very good. It's because what it did was it promoted the animosity between the parents. Anything we could do to sort of stop that was more helpful than continuing the arguing. That's why in our evaluations, when we make recommendations, sometimes we suggest parent counseling. We here at the agency have parent coordination, where it's 6 sessions where they come in or they do it on Zoom, and they work through a book and talk about some of these issues. Sometimes children have been estranged from parents and they don't want to visit a parent, or there's some issues. So we have reunification therapy, where we suggest that a parent and the child will go to therapy, and then the other parent will come in, because if you can get people talking, quite often they can get past some of the things that are causing the worst problems in a relationship after they've split up and they have to co-parent these kids. So they're constantly reminded that it's important to be mature, do the best you can. And some people have very valid concerns and hurts. Some people are worried about the children if they're with the other parent, and those are quite often very valid. And so a lot of times recommendations are made to address everyone's concern and everyone's worry in terms of what's best for these kids. Generally, the courts and the evaluators in custody feel that most of the time the kids need access to both parents. They need them to act right. They need them to act in a mature way. They need them not to badmouth the other parent, but they need access because that's part of who they are. And if they don't have that, it leaves a real hole for these kids. As a judge, I talk to kids a lot. And also I would talk to kids if it was requested, because I couldn't just decide. I could decide to talk to kids, but generally it would be requested by one of the attorneys. We never said to kids, who do you want to live with? Because kids don't get to make that choice. And I know some of you have heard that when kids are 12, they can choose who they want to live with. That is not the law. The law is they can't technically choose who they want to live with or decide where they're going to live until they're an adult, 18. They can give their opinion, and that's what we were interested in. So at 12, they can tell the court where they would prefer to live. And so when we would interview the kids, we would say, have you given it a lot of thought? What about leaving your friends? Did you know you're going to have to change schools? We were looking to see if one parent or the other parent offered benefits to the kids to ask for that change. The older the kids got, the more credence we put in their request to change. Sometimes they had very good reasons. Sometimes they just wanted to be with the other parent. I had a lot of teenagers who say, my parents have been divorced since I was 3. I've always lived with my mom. I just want to see what it's like to live with my dad for these next 3 years. And that was a valid request. And so if we're dealing with both parents who are not good, but who are competent, reasonable parents who it would not be concerning to place with that parent, And quite often that's the majority of them. If we had those kind of parents, then yeah, a 15, 16-year-old, we would listen to what they want. In our evaluations for custody, the kids quite often tell the evaluator who they want to live with. Now, the evaluators are skilled enough to find out if that's something that you were told to say, you were encouraged to say. And because we see the kids both at mother's house and then on a later day at dad's house, we can see if stories change, if they still remain the same. We can ask their reasoning for why they want to do that, and all get put into the report in terms of what the child said and what the child would want. So that's basically, I think, in custody cases, parents sometimes do see it as winning and losing. Kids, you can tell if the parents see it that way because the kids talk to you as the evaluator about that. Sort of like I said before, we're in a war. They're fighting, somebody's got to win, somebody's got to lose. If you can get them to a place, either by a custody evaluation or a mediation, or even talking in court, where they both feel that the kids have won, that's sort of the best thing you can do. Quite often I'd talk to parents and I'd say, you're both going to destroy your kids if you keep this up. And I would know that one parent was sitting there agreeing, thinking it was the other parent's fault. And the other parent was sitting there thinking it was the first parent's fault. And nobody wanted to take responsibility for it. And we would see these broken children who just want their parents to get along. You have a lifetime of dealing with the other parent. You have 5th grade graduation, 8th grade dance, you have proms, you have all sorts of things, you have weddings, all these things that kids are going to deal with the rest of their life. And all they want are 2 parents that can get along. Our job at the DRO and our job in the courts is to try, hopefully, and get those families there. Through the evaluations we do for custody, that is what we try and do. We try and point out the concerns, point out all the strengths, make recommendations, and hopefully parents can learn to live with those suggestions and become more comfortable in co-parenting. It is difficult to co-parent. I co-parent right now one of my grandchildren with his aunt, and we talk 2-3 times a day, and it is still difficult to make decisions for a child when there's 2 adults making those decisions. Imagine not liking the other person and having to make those decisions, but it requires people to sort of rise above themselves and to sort of say, no, I'm going to put my child first. I'm going to deal with it. It is not easy. And we recognize that, but we are here to help people and to serve people and to see if we can make people's lives better. And all our evaluators and mediators are really committed to that. And we're hoping that we can help the people of Harris County and some of the other counties that we service. We're hoping that we can help them do that. Speaking of other counties we service, we do some out-of-county things. If the child's here, parent's here, and the other person's moved to Seattle, quite often we take a trip to Seattle. We do all those things. So we're going all over the United States, trying to help these parents figure out how they're going to do this. And it's all for the benefit of the family. Okay. Well, let's see. It's not quite an hour. Are there any questions? I could probably keep talking about this and lecturing everybody because I'm used to doing that. But I want to know if there's any questions or any comments.
There's a question when you mentioned something about the vaccines, and the question was, vaccines go under which?
Oh, not vaccines, invasive medical. I'm
Ms.
saying,
Kelly,
you mean like COVID vaccines?
Miss Kelly, do you want to unmute yourself and ask directly?
Yeah. Hi, I'm Kelly.
Hello.
Yeah, that's not considered invasive, is it? Or is that?
I don't
I mean,
think
vaccines
that's
in general, but also COVID vaccines.
That is a problem. And that the courts deal with that a lot in terms of one parent believes in vaccinations, another parent doesn't. Usually what happens is one parent gets custody or not custody. One parent gets the right to decide certain things. It's not one of the rights and duties. Invasive medical is not getting inoculations. I don't think they consider that at all. That might be
Okay.
even getting your teeth pulled or having, being put out. And then quite often a parent just does what they want with regard to that. And that is very frustrating. If you have a mediation, quite often you can see there's things that go into a final order that a court wouldn't order, but that can be put into an order if parties agree in mediation. So that might be something, if you're mediating, could go into an order saying the parents agree this will happen or this won't happen. That is a problem. It's been a problem. The COVID thing was a problem, but even just general inoculations has been a problem prior to that.
Okay, thank you.
Okay. That was the only question that was in the chat, but from listening to your presentation, it kind of brought up a couple of questions that I actually had.
Sure.
What do you say to people that say that the court system, or playing devil's advocate here, is not favorable to a lot of fathers when it comes to custody?
I think that used to be the case 20 years ago. I think we have a more diverse judiciary and probably a more diverse bar in terms of all sorts of things. And I think you have fathers who are much more involved in the kids. 30 years ago, if mom stayed at home and dad worked, basically you looked at who was the person who took primary care of the child. And it was usually mom. Things have changed now. And so now you look at who's really dealing with the children, who's taking them to daycare, who's picking them up from daycare, who bathes them, who does this. And if you have a father who's more involved than a mother, then quite often fathers might get custody. As I say, when you do the visitation and the possession and access, because it's almost equal, nobody's really out a lot of time with their kids, but it clearly has changed. I know that people are worried that some judges feel a certain way. I think judges try and fight their prejudice all the time because we all have ideas about how families should behave and what should happen. But generally, we look at who the child is attached to. Some kids, it is clearly one kid is attached to a parent or a certain parent, either mother, father, much more than the other one. And it becomes obvious when you see them together, when you chit chat with the child, when you talk about the activities they do. And so I think it's a case by case basis, and I think it has changed. And I think it's much more even now.
I've seen it several times, unfortunately, where I know that there are fathers that seem to be better fits for their kids, and have a better income, more stable environment, so on and so forth. And custody is still given to the mother because it's the mother, especially if it's a female child. Like if it's a daughter, if it's a father that wants custody of their daughter or daughters, that they'll still give custody to the mother.
A lot of it also depends on the child's age. Now you get a 12, 13-year-old and on up through teenagers, they listen to what the kids want. And usually the kids have an opinion. Sometimes they don't, but they pay a lot of attention to it. Little kids, a lot of it depends on the content. Just because I don't think we looked at the income of the parent as much as the connection of the parent. Mm-hmm. So sometimes, yeah, dad has a lovely house. He's bought this house in a nice neighborhood. Mom has an apartment because her income is lower than dad's, but the child always has been with her, has been connected to her. Right. Sometimes it's the reverse. And dad lives in an apartment, but he's the one that takes her to daycare and deals with the teachers and takes her for her medical things. And then that's when we would look at dad. I think our evaluations are pretty equal. I can't always speak to the judges because, as I say, in court hearings, you only get to hear bits and pieces. You don't get the full picture quite often. And they look a lot at people's backgrounds in terms of criminal history, CPS history, those kind of things, how they carried themselves, how they deal with other people. And I'm sure there's residual where that's probably true. The mother more often gets that. But there's been Fathers for Equal Rights and some of the other organizations that have helped the dads. When you're doing it by yourself, it's difficult. If people have an attorney, quite often they have an easier time, but it's hard when you're doing it by yourself. But I would hope that it continues to change. I do feel our evaluators here are pretty good at sort of looking at the whole situation rather than have preconceived ideas.
And that was Fathers for Equal Rights? Is that a
Yeah, there's
local
Fathers for
organization?
Equal Rights.
Okay.
And yeah, I think there's some other organizations, I'm not really sure, but I know that dads would go in and talk to them, get advice, figure out what to do, and how to present their case. It's hard if you're doing it by yourself
I understand.
because you don't get all the information out. Go ahead.
Yep. Ms. Kelly, you have another question?
I do. I was talking about that, just thinking about how times have changed, how it seems there are quite a few more working mothers now. If that possibly affects the time that whether that's the primary residence or like I sit here and think about like the standard or the expanded time, and how much time, for instance, like I'm the primary residence, and how much time I actually do get with my child because he's either in school, he's in elementary school, he's school age, or I'm working. And so it's like that 47%, 53%, if you're actually taking just school into account, like it's
Yes.
pretty unbalanced, actually. Do you think that'll
Yes,
ever
the other
come into
side.
consideration?
It doesn't really, but you're right. I mean, except you get 2 weekends, the other parent gets first, third, and fifth weekend. So yeah, that is a problem because I can see what you're saying, that if you get your 53%, but most of the time it's just general living and not playtime, not
Yeah.
vacations, not, yeah, it's still 53% that you have care and control of your child. But I do understand, but that doesn't come into play when you're deciding who should decide the primary residence.
Okay.
Nobody says, oh, okay, but since the child's in school 8 hours a day, let's take those 40 hours away, and actually mom doesn't have that much access to the child. No, I don't think you have to
Okay.
worry about that. It's sort of who deals with the child, who sort of,
Yeah.
and quite often it's pretty obvious, especially with little kids. Now,
Yeah.
and sometimes that's when you get, these convoluted visitation schedules that are absolutely equal because dad's real involved. If dad's not
Yeah.
real involved, then it's not it's not as much of a difficult decision. We just looked
Okay.
at who the kid was really connected with. Yeah.
Okay, thank you.
Okay, there was another question that I had when we were just talking just now about, kids making decisions about which parent they want to stay with. At what age, or I'm not sure if it's a law or what have you, but at what age can you force a child to continue to visit? If they decide, I really don't want to go over there anymore. I don't like being over there. I'm mistreated. I'm whatever. I don't want to go. Does the parent then still have to force the visitation with the other parent?
Technically, yes. If they don't, they're going to end up in jail. They could. Now, what you do in that circumstance is you file a modification and you say, based on my child's fear or whatever, or the way the other parent treats him, he does not want to go over there. And I've had many hearings where the parent would say, I can't get him out of the car. He's 14. I can't drag him out and make him. Now, some judges would talk to the kids and say, look, if you don't go, then your mom or your dad can be held in contempt and we could put her in jail. I don't think that was real fair because I don't know what's going on. And I've had kids look at me after explaining what goes on at their parents' house, the other parent's house, and say, would you want to go over there? And I'd think to myself, no, I wouldn't want to go over there either. But if there's a court order that says this is what has to happen, the other parent's always within their rights to say, I'm going to ask to put you in jail if you don't. Now, you can take your chances in those enforcement hearings, if it ever goes that far, and put on testimony that says, this is why. But a change, a modification should be followed with the courts to give the court the ability to change the underlying order. If you come with an enforcement and you say he's beating the kids, he's doing this, he's doing that, and I apologize for saying the dad is, but we'll just go with the scenario. And you say, and so my child won't go. The court cannot change that order. They can say, yes, you're in contempt, or no, you're in contempt, but they can't change the underlying order that gave dad visitation to begin with. The only way they can do that is if you file something saying, please change it. Sometimes kids come and say, mom's drinking all the time. I'm afraid to drive with her. This is what's happening. If it's egregious enough, then people need to call CPS. And then once CPS gets involved, it's a whole different matter. And sometimes CPS will recommend stuff probably against a court order, but then, but parents need to reach out to somebody. If they just disobey a court order because of the child saying no, it can end up being problematic, even though it might be a really good idea that the child says no.
Speaking of CPS, what do you do? What does the non-custodial parent do when they know it's an abusive situation? They've repeatedly reported things to CPS, and CPS really doesn't investigate. Like, you just so happen to get that one person at CPS that just really doesn't do a good job, and they know that the child is physically being abused, but CPS still does nothing about it.
Well, you have to understand that parents exaggerate stuff, and they make reports sometimes when they're involved in custody battles that they presume that things are happening when they're not really. However, if it's ongoing abuse, there's several things people can do. They can continue to call CPS and make new reports, and that CPS should talk to the children. Now, when they're very little, it's difficult. Some parents put their kids in therapy. And if the child discloses to someone other than a parent. So if your child tells a teacher, a counselor, a therapist about some sort of abuse, quite often it appears that CPS will take that into account very quickly. If it's a parent going through a divorce, people are a little reticent and they do their investigation, but they always wonder, is this because there's a custody battle going on? And parents do use CPS when there's a custody battle going on. And so, and it's hard because kids will say things and parents sometimes lead them. Where did you get that bruise? You just came home from mom's house with that bruise. How did that happen? Now, do kids always tell the truth? Who knows? Maybe they don't know. Maybe they did. Did mom's boyfriend do that? How did that happen? That kind of questioning is probably not super helpful, but people need to know what's happening with their kids. And if they don't trust their spouse or their previous significant other, it's a concern. But you just don't give up. If there's stuff there and CPS won't do anything, then you make another report. And you try and do the best you can to see if the child will make another disclosure without you discussing it with the child, without you talking about it. That comes out. If you're the parent that's worried and you've talked about it with the child, it comes out as coaching, and people want to see there's spontaneous concerns and complaints from the child, and then they believe them more. But if CPS doesn't do anything, you just don't give up.
Okay. There was a follow-up question to the forcing of the child. It says, is there a proof that you should provide when they refuse to go for no other reason than not wanting to, and you cannot physically force them without practically hurting?
Well, and I understand teenagers. I mean, they become defiant, and why don't you want to go? I just don't like mom. She yells at me too much. She won't let me use the phone. I'm not going. I think all you can really do, it depends a lot on what the judge says. Probably the judge, whether or not they would hold the dad in contempt, would probably order some counseling. There's some reason why the kid doesn't want to go. Maybe mom's boyfriend is abusive, or he can't stand mom's boyfriend. He doesn't want to go, but it's difficult. And so you got to try and find out why he doesn't want to go. You know, dad's never home. He leaves me with grandma. It's too boring over there. I don't know. And as a parent who's supposed to encourage the visitation, I think you have to make a judgment on how bad is it. Does the kid just not want to go because if he talks back to his mom, his phone gets taken away? Or does he not want to go because he can't stand her boyfriend who's bowing up to him all the time and being sort of a jerk? And so I think you have to, as a parent, make a determination with regard to that. You probably need to talk to an attorney, because trying to decide what to do if you're going to disobey a court order is a serious matter. And you don't want to put yourself in that position without legal advice.
Gotcha. Another question. When you were mentioning or talking about passports, what happens if one of the parents decide that they don't want to allow their children to go out of the country or out of town, like into another state or something like that? Then what happens, even if it's like vacation?
If you out of country is one thing, but during your access time, unless there's a restriction put in your order, you can take the child anywhere, unless there's a restriction. Out of the country, quite often people address that in their final order, because that's what controls. And so they will say, and sometimes they pick certain countries you can't go to. Sometimes they're worried about violence in other countries, which they probably have a right to be. And so the more parents can work it out, the better. Now, sometimes they come in and we don't want our child to go such and such, but both of these parents were born in this other country. So the judge will say, well, wait a minute, you know, all dad's relatives are over in that other country. He needs to be able to take his child to the other country. Now, if dad's gone around and said, and there's people who have heard him say, I'm going to take him to this other country and you're never going to see him again, then on a case-by-case basis, they make a determination about what should be done with the passport. Sometimes there's restrictions about, has to say where he's going, the flight, who he's going to stay with, those kind of things. And sometimes people are precluded and ordered that they may not take the child out of the country. A lot of it depends on previous behavior of each parent and whether or not it's safe for the child.
What about visitation when another parent lives in another state?
You get different visit. Oh yeah, you get different visitation if you live in another state. You get 42 days in the summer rather than 30 days in the summer. You get spring break. Every spring break, you don't divide that. You still, Thanksgiving is switched every year and Christmas is divided. That still stays the same. So you get more visitation if you live in another state. You can opt to do 1 week in a month. You can still do the first, third, and fifth weekends if you want to, if you have the money and all that kind of stuff. And parents, they put in the orders flight information, who's going to take the children to the airport, if they're too young, if somebody's going to fly with them or not. As they get older, quite often they fly themselves. But there's no restrictions that if you live in Wisconsin and your order's from Texas, you get to have your child in Wisconsin if you want to. If you can pay the airfare and you can deal with it, the parent here in Houston doesn't get to say no.
So who's responsible for paying the airfare though? Like who has
Visiting parent.
The visiting parent.
Usually it's the visiting parent unless, and I've seen a lot of mediations where dad doesn't have to pay child support if indeed he proves that he's paying for the flight for the kid 4 times a year. I mean, there's ways you can sort of fashion paying money to make it fair. And a lot of parents who here in Houston they know that the child needs to visit the other parent. And so the parent here might make concessions about, okay, instead of $800 a month child support, you pay $300, but then you're going to pay for the travel. Sometimes if travel's in Louisiana, parents agree that they're going to drive and they're going to meet someplace halfway. But the parent who has the child, who determines the primary residence, isn't tasked with that responsibility. They can magnanimously agree to do that for the benefit of their child and to help this out. But generally, it's the parent who moved to another state who pays for the travel.
So then what if you move out of state with the child? Then it becomes your responsibility to make sure that the kid gets back for visitation?
Generally, that's what I would, well, a lot of times these orders have a geographical restriction for the child. So the child has to live. Now we weren't restricting the parents, we were restricting the child. Child has to live in Harris or contiguous counties. So generally that parent cannot move that child to another place. If that's not, and that's in almost all orders with regard to the kids. Usually part of the language says that so-and-so is awarded the right to determine the primary residence with a geographic restriction to Harris or contiguous counties. So once that's in place, you can't move the child unless they modify and they agree to do that. And then as part of the modification, you figure out who's going to pay for visitation, who's going to pay for the access. But if the child ends up moving out of the state, then the parent who's moved out of the state could try and get the case moved to the other state. So quite often parents don't want to allow the other side to move the child, especially if they're involved parents. Because if your child moves up to Michigan and you've been participating in gymnastics or baseball or whatever with your kid on a regular basis, you're going to lose all that. And generally the courts won't allow it, but it's on a case-by-case basis.
So if you're interested in moving out of town or to another state or whatever, and you get the other parent's permission, then you definitely want to make sure that you get the order amended prior to you moving, not just going by
Yes.
their word saying it's okay.
Their permission is not enough because you got a court order, the judge says this, and you have to abide by it. So yeah, if he agrees or she agrees, then you draft up a change, a modification, put that in there, and then everybody's okay.
Okay, good deal.
That's why there's so many modifications. That's why so many people are constantly going back. They're modifying and changing their orders because it's impossible to do an order when the child's 2 or very difficult. That's going to cover the next 16 years. It's hard.
Okay. All right. What about paying for college? Generally, who's responsible for after 18 or after 17?
When the child turns 18, parents no longer financially, once the child graduates from high school and is under 20 and is under 21, parents no longer responsible. So there is no way that the court can order somebody if they don't agree to pay college. Parents can agree, they can agree in mediation. Sometimes they agree because they're dissolving their relationship or a marriage, that here's this house and I won't take this much of the house if you will pay for the first 2 years of college, providing she gets A's and B's or keeps her grade point at this and does this and this. But there's no way a court can make a parent responsible for somebody after they become an adult, unless they're a disabled adult, which is a whole different matter. But a regular kid in college, no. If they want to, out of the goodness of their heart, they can, or they can agree to it, but a court can't order it.
I thought there was something, I'm not sure if this was where I heard it from, that if a child graduates high school and they're going on to college, that you're still legally responsible for the medical insurance or something while they're still in college up to a certain age?
Not according to the family code. Now, clearly,
Okay.
the insurance companies are allowing you keep them on your insurance until they're 26.
Okay,
And so you can do that, but that's not something that would be ordered that you have to do
okay,
in a court order.
okay, all right. I'm just kind of thinking of stuff as I go here, because
Sure,
I've
absolutely.
heard all kinds of scenarios that people, sit around and talk about on a regular basis. I'm just thinking about everything that I've heard just about every story you can imagine. Well,
I bet.
I'm sure as being the judge over these cases of every kind of custody dispute and what happens and the reason people come to court and don't come to court and so on and so forth, that it's just it's mind blowing. So God
Yes.
bless you for even taking on that role. I mean, that's a big
It's hard.
responsibility to decide.
It's hard for people to come into a court, especially if they don't have a lawyer, and try and function in the system. It's very difficult. And they have to do it quite often. And so that's why we're trying to offer services to help them get through, because things need to be done sometimes.
This was my last question when I saw her comment about child support. What do people do, especially over the last couple of years with COVID, people being out of work and financial hardships or what have you, when they're still ordered to pay child support, but they have no jobs, they've lost their jobs, or what do they do?
Technically, they're ordered to pay the child support. If an enforcement is filed on them and they go to court, they can give testimony about they no longer have the resources, they're unable to do it. And they might not be held in contempt, or they might work something out. I have found in my years that the parent who's receiving the child support, if the other parent makes some attempt, say the parent's supposed to pay $500 a month, they've lost their job, and they pay $150 a month. Quite often the receiving parent they let it go because they know what's happening. But you can take somebody to court. They will probably end up modifying that underlying order to change the amount of child support. But the courts are reasonable, and they understood that people lost their jobs. Economically, things were bad. Of course, the stimulus money, people didn't like to necessarily consider that as something that they should take child support out of. But so they try and do the best they can. And usually it's a better outcome than just deciding not to. Or say you have somebody who loses a job and they quit paying, but then they show up in a new car. Well, that doesn't go over very big for the parent who's been expecting child support and is not getting it for these kids. But the courts have been reasonable, I think, about understanding that people are in bad situations. Sometimes they will reset the hearing, give you another 3 months. Let's come back and see where you are in 3 months. Because if you don't have it, you don't have it. But they will look at your finances. Where are you spending money? Where are you getting money? How are you living? Who's paying for your cell phone? All those things, that they take into account. So it's probably case by case, but I think the courts have been more sensitive to it. And they don't usually, that you're not brought up on child support issues unless your spouse or your significant other files a child support enforcement against you generally. So if the other side understands and everybody's working together, usually people can work that out.
Okay. Well, that was it for my questions as is. So are there any other questions from any of the participants? Check comment section on Facebook here. So if you have any other questions, please feel free. We have our experts at your fingertips here to ask whatever questions that you like. So thank you, Ms. Kelly, for your input and your questions and your participation as well. So Ms. Patterson, I think you pretty much covered all the bases. So
Okay, I know I went pretty fast. So
well, that's also why we record this session too, for people to go back and review and watch it again in case they did miss something or in case they have another question, they can go back and actually review it, or know somebody that's going through custody issues or what have you, or don't know where to start, that they can share it with somebody else as well. So again, thank you very much for taking the time. Susie, you just unmuted yourself. You have a question?
Yes, I do have a question.
Okay.
I'm sorry, I got on late. However, I'm in a situation where I'm kinship care. And the father, they have declared that he is the biological father. And so he's in the process of wanting the baby to be moved with him. And my question is, what do, first of all, the baby's mother is my great niece. So the baby is my great great niece. And I'm trying to see, we've been having her ever since she was 4 days old. I have. She's now about to be 9 months old. And I'm trying to find out, what rights do I have as a kinship caregiver as far as being able to keep the baby in, keeping in touch with the baby, and having rights to see her if they decide to give the baby to the dad, where, you know, it was supposed to be a unification. And we go to trial in August. And I'm trying to find out, what rights do we have, the mother side of the family have. She's currently incarcerated. And right now, she has some mental issues, and she's incompetent right now to stand trial, go to trial for the baby. So as a kinship parent, what right do I have to keep the baby in our life as well?
Is this a CPS case?
Yes, yes.
Do you have an attorney?
No, not personally, but she does. She has, the baby has an attorney and the father has an attorney, but we do not have a personal attorney.
There's so many issues. Certainly, you might be able to ask for that, but the problem is you can't get anything out of the court that you want without asking, like filing a motion or filing a pleading. You can't just go and ask for things. The court has to have some sort of pleading from you in terms of what you want. I understand wanting to keep contact with the maternal side. I would suggest that you get an attorney, and if you search around, somebody may be able to help you. I know they're sort of expensive, but they would be able to give you advice about what could be filed and how it could be approached. And sometimes people even settle CPS cases in mediation. So that might be something that you can think about. But I think trying to do this by yourself is going to be very difficult. And I don't know mom's situation. I assume mom has an attorney as well, right?
Yes, yes, CPS.
And so maybe you could talk to the attorney, and but I think my advice to you is, I think you have to get legal counsel, because if that sounds like a rather complicated matter, and if you're coming up to a trial and it's that serious, then I think you need somebody to advise you.
Okay.
Miss
right.
Susie,
Sorry.
we'll when I send out the link for this recording for you to go back to watch, I'll also include our legal service partners information, so that you can reach out to them to see if you can apply for their services.
Okay.
The partners that we partner with at A Month of Services do offer their civil legal assistance at no charge or low cost, depending on which one you could potentially qualify for. So I'll send you their information.
Okay, I appreciate it. Thank you so much.
Okay.
Mhm.
All right. Well, I believe that is it. And again, I
Okay.
think we pretty much covered all bases. So thank you very much, Ms. Patterson. I really, really
You're
do
welcome.
appreciate it.
I hope I
so-
answered everybody's question.
I
if they had
believe
any.
so. Yes. Let's see, what do we have coming up? We are on Thursday, we are doing our monthly Will of Life Will Clinic in partnership with the City of Houston's Health Department and the Harris County Area Agency on Aging to do wills and estate plans at no charge. Next Tuesday, as part of our community empowerment series, we're doing mediation versus arbitration, as well as on Wednesday, our maintaining and adding value to your home and getting prepared for hurricane season. So we're doing disaster readiness. That's coming up next month too. So we got quite a bit. I will, again, when I email the link out, I'll include the legal resource information as well as our calendar, our schedule of everything that we've got coming up for this month. We ask that everybody just take a couple of minutes after this particular session is over with to answer a few evaluation questions that we have. And at that time, you have the opportunity to give us your feedback as far as other topics that you'd like to hear more information about. We are having our planning session in a couple of weeks for us to plan for our fall session. We take the month of July off as much as possible with people traveling, vacations and things of that nature. But we're planning again for starting up to gear up again for the fall. So we're going to be planning those sessions and want to hear from folks. You know, what else is it that you like more information about? What is pertinent to you? What's going on in your neighborhood? You know, within your family or what have you that we have not currently covered, that we don't currently offer. That we would love to have your feedback from that. So once again, Ms. Patterson, thank you very much for taking your time out this afternoon. And on behalf of the Houston Bar Association, we thank you for representing today. For everyone else that's joining us this afternoon, thank you very much for your participation and continued support of A Month of Service and coming back. We invite you to continue to come back and join us for other workshops. Our workshops are free. We try to provide the most up-to-date information that we possibly can, because we know rules and laws and processes and things of that nature change on a frequent basis. So we try to provide those experts to you that can provide information about those particular topics for you. And also to let folks know about resources that are available. You know, some people really just don't know where to go for help, who to start, where to start, who to talk to, what questions to even ask, and so on and so forth. So that's what we're here for. And thank you again very much, everybody. We hope that you all have a wonderful remainder of your afternoon. Continue to stay safe, stay healthy. Ms. Patterson, you have a wonderful afternoon. Thank you very much.
Thank you so much. Take care.
All right, take care.